Please rise. Thank you. Sit, please.
We're good, Judge.
Good morning, ladies and gentlemen. Reminder, everybody, I'm sure your cell phones or other electronic devices are off. And we'll proceed here this morning then with the jury instructions on the case. I'm going to give you the substantive instructions and what we'll call substantive instructions on the law. Then we'll hear the closing arguments of counsel. Then I'll have some additional instructions on how to conduct your deliberation return a verdict, and then you'll retire, or you won't retire, we will retire, since you're going to be using the court. I also remind counsel, in case I forget, that when we do lose the court for deliberation, make sure you take everything with you, since the jury won't have that, as you know. All right, this is the first time I've had to instruct a jury, pedigree, with you there in the back. Usually I look over here and look at you, but I'm not able to do that here, so I apologize for that. I will try to keep my voice up. I know with all of the modifications we've done, I know it's effectively acoustic to some extent, perhaps more for me, and those of you that are in the back row. But in any event, I'll try to keep up or keep my voice up. If you have any trouble hearing me, raise your hand, okay? All right. Ladies and gentlemen, you've heard the evidence. It's now the duty of the court to instruct you as to the matters of law. The court and the jury have separate functions. You decide the disputed facts, and the court will provide the instructions of law. Now, ladies and gentlemen, it's your sworn duty to accept these instructions and apply the law as it is given to you. You're not permitted to change the law or to apply your own conception of what you think the law should be. Now, all criminal cases begin with the filing of an indictment. As I indicated to you at the beginning of the trial, the indictment informs the defendant that he or she has been charged with an offense. The fact that it was filed may not be considered for any other purpose. Defendant's plea of not guilty is a denial of the charges and puts in issue all the essential elements of the offenses. The defendant is presumed innocent until her guilt is established beyond a reasonable doubt. The defendant must be acquitted unless the state produces evidence which convinces you beyond a reasonable doubt of every essential element of any one or more of the offenses that have been charged in the indictments. Now, I see I made a typo there, so I'm going to fix that here before I continue. All right, now, reasonable doubt is present when the jurors, after they have carefully considered and compared all the evidence, cannot say they are firmly convinced of the truth of the charge. It's a doubt based on reason and common sense. Reasonable doubt is not mere possible doubt, because everything relating to human affairs or depending on moral evidence is open to some possible or imaginary doubt. Proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely and act upon it in the most important of that person's own affairs. Now, ladies and gentlemen, you're the sole judges of the facts, the credibility of the witnesses that were presented, and the weight of the evidence. Now, to weigh the evidence, you must consider the credibility of the witness. You will apply the test of truthfulness as you apply in your daily lives. These tests could include the appearance of each witness upon the stand, their manner of testifying, the reasonableness of their testimony, the opportunity they had to see, hear, and know the things concerning which they testified, their accuracy of memory, their frankness, their lack of it, their intelligence, their interest and bias of any, together with all of the facts and circumstances surrounding their testimony. Applying these tests, you'll assign to the testimony of each witness such weight as you deem proper. You do not decide any issue of fact merely on the basis of the number of witnesses who testified on that side of the issue. The final test of judging the evidence should be the force and the weight of the evidence regardless of the number of witnesses on each side of the issue. You are not required to believe the testimony of any witness simply because that witness was placed under oath. You may believe or disbelieve all or any part of the testimony of any witness. You will determine what testimony is worthy of belief and what testimony is not worthy of belief. Each witness was subject to direct examination by the party who called them and cross-examination by the opposite party. During the trial, counsel was able to inquire into some matters that did not directly relate to the issue before the court. Those questions and answers were permitted for the purpose of helping you to determine their credibility and the weight to be given to their testimony and for no other purpose. The testimony of the defendant is to be weighed by the same rules that apply to all other witnesses. Now, generally, a witness may not express an opinion. However, one who follows a profession or special line of work may express his opinion because of his or her education, knowledge, or experience. Such testimony is admitted for whatever assistance it may provide to you to help you arrive at a just verdict. However, as with other witnesses, upon you alone rests the duty of deciding what weight should be given to the testimony of the expert. And in determining its weight, you may take into consideration his or her skill, experience, knowledge, veracity, familiarity with the facts of this case, and the usual rules for testing credibility and determining the weight to be given to testimony. Well, ladies and gentlemen, evidence is all of the testimony that was received from the witnesses and any exhibits that the court has admitted into evidence during the trial. And I'll tell you now that there were some exhibits that were pre-marked or not testified about, and so they were not offered, or maybe they were offered and they were, for reasons of law, not admitted. So if you will find that there are some numbers missing, so don't ask for those because those were left out because of legal reasons. Now, evidence may be direct or may be circumstantial or it may be both. Direct evidence is the testimony given by a witness who has seen or heard the facts to which they testify. It includes, of course, exhibits admitted into evidence during the trial. Circumstantial evidence is proof of such facts or circumstances by direct evidence from which you may reasonably infer other related or connected facts which naturally and logically follow according to the common experience of mankind. To infer or to make an inference is to reach a reasonable conclusion or deduction of facts which you may but are not required to make, or the other facts which you have found have been established by direct evidence. Whether an inference is made rests entirely with you. But considering circumstantial evidence, you may not draw one inference from another inference, but you may draw more than one inference from the same facts or circumstances. In other words, you cannot stack one inference upon another inference to reach a factual conclusion. Now let me give you an example of that, because it may be a little bit confusing. You have children involved and you have a cookie jar, and you walk in the kitchen and you see that there are cookie crumbs. You can infer from that somebody's got cookies out. Now you can infer from that which you can also infer that one of the children have done, but you've got 4 children. You can't decide which one did it based on that inference alone, that circumstance alone. It would require other circumstances to go on that. So that's what it means. That's an example of stacking on top of each other. You can only make the inferences of those circumstances. Now, if the circumstances create inferences that are consistent with either guilt, acquittal, or guilt, then the defendant must be acquitted, unless the inferences in favor of guilt rise to the level of proof beyond a reasonable doubt. In the absence of direct evidence of a person's guilt, circumstantial evidence by itself may justify a finding of guilt if the circumstances are entirely consistent with the defendant's guilt or wholly inconsistent with any reasonable theory that she is not guilty and are so convincing as to exclude reasonable doubt of guilt. Where the evidence is both direct and circumstantial, you must decide whether the combination of the two types of evidence overcomes the presumption of innocence and convinces you beyond a reasonable doubt that the defendant is guilty. Now, again, I'll state the evidence does not include the indictment, the opening statements, or closing arguments of counsel. Opening statements and closing arguments, as I indicated to you before, and will again, are designed to assist you. They are not evidence. Now, any statements that may have been stricken by the court that told to disregard are not evidence and must be treated as though you never heard. And I sustained the objection to a question that was already answered. Didn't tell you that. Nonetheless, that applies. You're treated as if you never heard. You must not speculate why the court sustained any objection to any question or what the answer to that question may have been. You must not draw any inference or speculate on the truth of any suggestion that might have been included in any question that was not answered. Now, a number of exhibits have been introduced, and testimony relating to them has been introduced and admitted into evidence. You may consider whether the exhibits that are the same objects are in the same condition as they were originally. You will determine what weight, if any, exhibits should receive in light of all the evidence. Now, the law regarding count 1, felonious assault. The law under which the defendant is charged in count 1 is entitled felonious assault and is numbered by Ohio Revised Code 2903.11a1. This law states in the pertinent part as follows: no person shall knowingly cause serious physical harm to another. Ladies and gentlemen, in this case, the defendant is charged in count 1 with felonious assault under that section. Before you can find the defendant guilty of felonious assault, you must find beyond a reasonable doubt that on or about the period of June 14, 2020, continuing through September 9, 2020 in Highland County, Ohio, the defendant knowingly caused serious physical harm to LH. Now, the essential elements of the crime of felonious assault is charged in count 1 are as follows. 1, that the defendant did on or about the period of June 14, 2020, continuing through September 9, 2020, 2, in Highland County, Ohio. 3, knowingly caused physical harm to LH. Now, it's not necessary that state prove the offense was committed on the exact date charged in the indictment. Sufficient proof that it took place on a date reasonably near the date claimed. Now, before you can decide whether the state of Ohio has proved beyond reasonable doubt all of the essential elements of the offense with which the defendant is charged, let's first decide whether this is the correct county in which this trial should be held. That's called venue. The state must prove beyond reasonable doubt that all or any part of the offense charged was committed in Highland County, Ohio. Now, a person acts knowingly, regardless of purpose, when the person is aware that the person's conduct will probably cause a certain result or be of a certain nature. The person has knowledge of circumstances when the person is aware such circumstances probably exist. When knowledge of the existence of a particular fact is an element of an offense, such knowledge is established if a person subjectively believes there's a high probability of its existence and fails to make inquiry or act with a conscious purpose to avoid learning the fact. Since you cannot look into the mind of another, knowledge is determined from all the facts and circumstances and evidence. You will determine from these facts and circumstances whether there existed at the time in the mind of the defendant an awareness of the probability that her conduct would probably cause a certain result or be of a certain nature. Proof of motive is not required. The presence or absence of motive is one of the circumstances bearing upon purpose or motive. Where an act is a good crime, where an act is a crime, a good motive or purpose is not a defense. The state charges that the act of the defendant caused serious physical harm to LH. Cause is an essential element of the offense. Cause is an act or failure to act which in a natural and continuous sequence directly produces the serious physical harm to LH, without which it would not have occurred. Defendant's responsibility is not limited to the immediate or most obvious result of the defendant's act or failure to act. Defendant is also responsible for the natural and foreseeable consequences or results that follow in the ordinary course of events from the act. Serious physical harm to persons means any of the following. A, any mental illness or condition of such gravity as would normally require hospitalization or prolonged psychiatric treatment. B, any physical harm that carries a substantial risk of death. C, any physical harm that involves some permanent incapacity, whether partial or total, or that involves some temporary substantial incapacity. D, any physical harm that involves some permanent disfigurement or that involves some temporary serious disfigurement. E, any physical harm that involves acute pain of such duration as a result of substantial suffering or that involves any degree of prolonged or intractable pain. Now, if you find that the state proved beyond reasonable doubt all the essential elements of the offense of felonious assault, your verdict must be guilty according to your findings. If you find the state failed to prove beyond reasonable doubt all the essential elements of the offense of felonious assault, your verdict must be not guilty according to your findings. Now, in count one only, there's a possibility of returning a verdict of a different offense than that included in the indictment. It's called a lesser included offense. That would be assault. If the evidence warrants it, you may find the defendant guilty of an offense lesser than that charged in the indictment. However, notwithstanding this right, it's your duty to accept the law as it is given to you by the court. And if the facts and law warrant conviction of the offense charged in the indictment, count one here, then it is your duty to make such finding uninfluenced by your power to find a lesser offense. This provision is not designed to relieve you from the performance of an unpleasant duty. It is included to prevent failure of justice. If the evidence fails to prove the original charge, it does justify a verdict for a lesser offense. Now, you must first consider the offense of felonious assault charged in the indictment. If you find that the state proved beyond reasonable doubt all the essential elements of the offense of felonious assault, your verdict must be guilty as charged, according to your findings. However, if you find the state failed to prove beyond reasonable doubt all the essential elements of the offense of felonious assault, then your verdict must be not guilty of that offense as to that count. And in that event, you will then continue deliberations to decide whether the state has proved beyond reasonable doubt all the essential elements of the lesser included offense of assault. Or, in a second circumstance, if you are unable to agree on a verdict of either guilty or not guilty on the felonious assault charge, then you will continue to deliberate to determine whether you find the state proved beyond reasonable doubt all the essential elements of the lesser offense, included offense of assault. Now, to explain the difference, the offense of assault under 2903.13a of the revised code is distinguished from felonious assault in count one by the absence or failure to prove beyond reasonable doubt the element of causing or attempting to cause serious physical harm to another, which is required to prove a defendant guilty beyond reasonable doubt of the offense of felonious assault she's charged in the indictment. But proof beyond reasonable doubt the defendant knowingly caused or attempted to cause physical harm. The law of assault is under Ohio Revised Code section 2903.13a and states in the pertinent part, no person shall knowingly cause or attempt to cause physical harm to another. So before you can find the defendant guilty of assault under this provision, you must first find beyond reasonable doubt on or about the period of June 14, 2020, and continuing through September 9, 2020 in Highland County, Ohio, this defendant knowingly caused or attempted to cause physical harm to LH. Now, the essential elements of assault are as follows. The defendant did at the same time in the indictment period, June 14 through September 9, 2020, Highland County, Ohio, knowingly caused or attempted to cause physical harm as opposed to serious physical harm to LH. Now, the instructions I gave you regarding the time and the venue are the same. I won't repeat those. The definition of knowingly is the same. You apply the same definition I instructed you on felonious assault, as well as the issue of motive and causation. But in causation, it is that the state charges that the act caused physical harm, not serious physical harm, for purposes of a lesser offense. Other than that, the same instruction applies. How do you determine? Now, an attempt occurs when a person knowingly engages in conduct that is successful with result in physical harm. Now, physical harm to persons, this is physical harm, not serious physical harm. Physical harm to persons means any injury, illness, or other physiological impairment, regardless of its gravity or duration. And so, if you find that the state proved beyond reasonable doubt all the essential elements of the offense of assault, then your verdict must be guilty according to your findings. If you find the state failed to prove beyond reasonable doubt all the essential elements of the offense of assault, your verdict must be not guilty according to your findings. Now, count two. The defendant is charged in count two with endangering children. Before you can find the defendant guilty, you must find beyond reasonable doubt on or about June 14, 2020, continuing through September 9, 2020 in Highland County, Ohio, the defendant did recklessly abuse LH, child under 18 years of age. The law under which the defendant is charged in count two is entitled Endangering Children and is numbered Revised Code section 2919.22B1. This law states the pertinent part as follows. No person shall do any of the following to a child under 18 years of age: abuse a child. The essential elements of the offense of endangering children are as follows. That the defendant did 1, on or about the period of June 14, 2020, and continuing through September 9, 2020. 2, in Highland County, Ohio. 3, recklessly abused LH, a child under 18 years of age. Now, again, the definitions of time and venue that I explained to you apply to this offense as well. And you will apply those definitions. Now, in this charge, the statement of proof recklessness or recklessness. A person acts reckless when, with heedless indifference to the consequences, the person disregards a substantial and justifiable risk that the person's conduct is likely to cause a certain result or is likely to be of a certain nature. A person is reckless with respect to circumstances when, with heedless indifference to the consequences, the person disregards a substantial and justifiable risk. Such circumstances are likely to exist. Risk means a significant possibility, as contrasted with a remote possibility, that a certain result may occur or that certain circumstances may exist. Abuse means any act which causes physical or mental injury that harms or threatens to harm a child's health or welfare. Now, if you find beyond a reasonable doubt all the essential elements of the offense of endangering children, your verdict must be guilty according to your findings. Find the state failed to prove beyond reasonable doubt all the essential elements of the offense of endangering children, your verdict must be not guilty according to your findings. Now, if and only if you find the state proved beyond reasonable doubt all these essential elements of the crime of endangering children that I explained, then you will make a determination whether the state proved beyond reasonable doubt that the violation of the offense resulted in serious physical harm in LH. Count 2 is LH. The definition of serious physical harm that I gave you for count 1, malicious assault, is also to be applied here. Now, result and cause mean the same thing. Cause or result is an act or failure to act which in natural continuous sequence directly produced serious physical harm, LH, and without which it would not occur. The defendant's responsibility is not limited to the immediate or most obvious result of the defendant's act or failure to act. The defendant is also responsible for the natural and foreseeable consequences or results that follow in the ordinary course of events from the act or failure to act. Now, the law on count 3 is also entitled Endangering Children, but has a different section number. It is numbered Revised Code Section 2919.22a. This law states the pertinent part as follows. No person who is a parent, guardian, custodian, person having custody or control, or person in loco parentis of a child under 18 years of age, or a mentally or physically handicapped child under 21 years of age, shall create a substantial risk to the health or safety of the child by violating a duty of care, protection, or support. So the essential elements of the offense of endangering children under this count are as follows. That the defendant did 1, on or about the period of June 14, 2020, continuing through September 9, 2020, 2, in Highland County, Ohio, 3, being a parent, guardian, custodian, or person having custody and control over a person in loco parentis, 4, of a child under 18 years of age, 5, recklessly created a substantial risk to the health or safety of the child, in this case, WH, and 6, by violating a duty of care, protection, or support. Now, this again, the same definitions that I've instructed you on as to time and venue also apply in this count. Now, the definition of guardian means any person appointed by a probate court to have the care and management of the person, the state, or both of the competent provider. Custodian means one entrusted officially with custody. Loco parentis means acting in the place of a parent or as a temporary guardian of a child. Child means a person under age 18 years of age or mentally or physically handicapped person under 21 years of age. Now, the offense of count 2, 3 also requires recklessness. Same definition I just read to you earlier, we will apply here. Now, if you find the state proved beyond a reasonable doubt all the essential elements of the offense of endangering children, your verdict must be guilty according to your findings. If you find the state failed to prove beyond a reasonable doubt all the essential elements of the offense of endangering children, your verdict must be not guilty according to your findings. And again, if and only if you find the defendant the state proved beyond reasonable doubt all essential elements of other crimes endangering children. You will also make the determination whether the state proved beyond reasonable doubt the violation of the offense resulting in serious physical harm to WH and free child involved. Definition of serious physical harm result that I instructed you to on the previous count two also apply and are to be applied. Now, if you find the state proved beyond reasonable doubt all essential elements of any one or more of these offenses charged in the separate counts of the indictment, your verdict must be guilty as to such offense or offenses according to your findings. Find the state failed to prove beyond reasonable doubt any one of the essential elements of any one or more of the offenses charged in the separate counts of the indictment, your verdict must be not guilty as to such offense or offenses according to your findings. Now, the charges set forth in each count in the indictment constitute a separate and distinct matter. You must consider each count and the evidence applicable to each count separately. And you must state your finding as to each count uninfluenced by your verdict as to the other count. Now that completes the instructions on the subject law, as I refer to it. And you are now going to, a minute or so here, in the closing arguments. I will tell you that this is a lot to take in, I understand. And so we will provide you a copy after making corrections for my paste errors. And you will have a copy of this with you during the deliberation so that you can refer to those definitions as you find it necessary to do so. Now, at this time, we will hear closing arguments. These are the positions of the parties of what they believe the evidence is proven. They are not evidence, they are simply designed to assist you in your deliberations and reaching a verdict. Since the state has a burden of proof, the state, just as we did in the presentation of evidence, goes first and then has the right to present a final summation and rebuttal to the closing of the defense. So at this time, I'll turn it over to Ms. Collins. You want to make an argument?
Yes. Good morning again. May it please the court, Mr. Justice Coalition. Ladies and gentlemen of the jury, I want to first thank you on behalf of my office and the Sheriff's Office for your time and attention to this matter. I know that jury service is not how you plan on spending your week, but our justice system is one of the few in the world that uses the jury to decide guilt. And that only works with citizens like yourselves, and for that I want to thank you. Now I have two opportunities to speak with you, so I'm going to keep the first opportunity short and to the point. When I presented my opening statement, I told you the state would prove that the defendant, the mother of William and Lucy, had abused and neglected her children to the point that they both suffered serious physical harm, and the state has proven exactly that. The defendant caused serious physical harm to baby Lucy when she broke 22 bones in Lucy's body and gave her a skull fracture. This is felonious assault of Lucy. The defendant's repeated abuse of Lucy resulted in serious physical harm to baby Lucy. This is child endangering of Lucy. And the defendant's reckless treatment of William resulted in him starving and suffering serious physical harm. This is child endangering of William. Now, this defendant is nothing if not in control of her house. She controlled Jacob to the point that he wasn't permitted to see his family. He wasn't allowed to have his last name on Facebook, so he used the name Jacob Blank. Jacob wasn't allowed to take the children anywhere because the defendant made it clear that she would have him charged with kidnapping. The defendant dictated Jacob's every move, and when he didn't do what she said, she called the sheriff and had him arrested. It was the defendant's way or no way. Now, the defense doesn't seriously dispute these children suffered serious physical harm. They dispute that the defendant caused the serious physical harm. But let's look at the timeline the defense helped establish. Jacob took the kids to see Pam Knightley on August the 6th, and Pam did not detect any broken bones in Lucy. Pam was concerned about William's weight gain, but not to the point of calling CPS or the sheriff's office. She wanted the children seen at Children's Hospital. Jacob went to jail on August the 13th and last saw the kids for more than a few minutes on August the 12th. Jacob testified that he didn't observe any broken bones in Lucy, and his testimony was that when he last saw Lucy, she didn't sound like a bag of potato chips. When Cindy and Zaya had the children from August 19th through August 25th, They didn't notice broken bones. They noticed the kids seemed hungry and were dirty. And when Taylor watched William and Lucy from August 26th through August 28th, she didn't notice broken bones. She did notice bruises, but thought maybe it was just kids being kids. On September 9th, 2020, Lucy was found to have 22 broken bones and a skull fracture, and William was severely abused. He was starving. So from August 28th through September 8th, one person had control of these children, and that one person was the defendant. Well, look at this on here. They want you to believe that Jacob caused these injuries? Jacob's not. Jacob's in jail. Jacob is in jail. Jacob is in jail. Jail, 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 jail. Jail, 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 jail. TPO in place. No contact, no contact. No contact. No contact, no contact, no contact, no contact, no contact. No contact, no contact. Finally, on the 8th, he gets to see Lucy. Then you have the statements of the defendant, her admission that she jerked on Lucy and put her on the floor too hard. That on Friday, September the 4th, the defendant noticed what felt like a water bubble on the back of Lucy's head after she slammed her on the floor. The defendant admitted that she heard Lucy's bones pop and crack when she moved Lucy. She admitted that she sounded like a bag of potato chips. The defendant said it freaked her out. From the beginning, the defendant has played the blame game, the not me game I talk about in my court here. But think of the testimony. Every person the defendant blamed, except maybe William, took the stand and told you they didn't cause these injuries to Lucy. In fact, they didn't realize Lucy had the broken bones. And think about baby William, a little boy that didn't have the strength to stand. It makes no sense this little boy could have broken Lucy's body when he didn't have the strength to pull himself to a standing position. A little boy that barely had the strength to sit up. Frankly, it's ridiculous to put blame on that innocent baby. But that's the true character of this defendant. Blame everyone, including your own child. The defense drilled Jacob about squeezing Lucy and breaking her ribs. And think about his explanation of that. Jacob advised that the defendant shoved him while he was holding Lucy, and he squeezed her and turned to keep Lucy from hitting a shove with her head. Again, the defendant was responsible for that action. And finally, you have the defendant's thoughts and feelings about these children to consider. During the interviews, the defendant showed no emotion. She was more concerned with getting her cell phone back. She said, I just couldn't wrap my head around not having it. She didn't want these babies. Jacob told you he asked why William's crib was for sale because he thought that the defendant had gotten rid of William. The defendant told Detective Angmore she didn't want Lucy at all. She was ready to sign her rights over to Lucy right then. The defendant admitted to Detective Angmore that her feelings for Lucy impacted the way she treated her. When I questioned you in voir dire, I asked you if you would never believe a parent could cause these type of injuries. And I asked that because I was confident that the state would prove that a mother caused these injuries. Lucy and William were completely innocent. They don't deserve this treatment. They did not deserve to be in pain. Imagine the pain of 22 broken bones and a skull fracture. Imagine the pain of being so hungry you crawl to the trash can to try to eat food. Imagine a child not growing at all because every bit of nutrients that he is getting is going to keep him alive. Ladies and gentlemen, 22 broken bones and a skull fracture, that's felonious assault. Repeated jerking of Lucy's arms and legs, resulting in broken bones is abuse and child endangering of Lucy. And reckless, complete lack of care of William, resulting in him starving and deteriorating, is serious physical harm, and that's child endangering of William. The state has proven each of these crimes beyond a reasonable doubt.
Please support as follows, as shown in the jury. The state does not have the burden in this case. This case has got a lot of information. I only get one chance to address you, so I'm going to look it on. First, I'll start with Dr. Thackeray's testimony. Although it was tedious to go through each and every bone and the amount of bone formation that each and every bone had, I usually thought that was necessary. No bone formation indicated that the injury occurred within the last 7 to 10 days. Small amount of bone formation was between the 7 to 10, 14 to 21 day range. Moderate bone formation, Dr. Thacker said it's a little bit harder to tell what the end result would be, but outside of 21 days was not out of the question. And abundant bone formation, just like moderate bone formation, was difficult to tell, but definitely not outside the 21 days. And that bone formation would not appear within 10 to 14 days. So by the doctor's own testimony, those injuries had to be older than 14 days, and there is no tail on that, so if you went back in months. This is important, because when I went through and asked about each and every rib, we found that 9 ribs had abundant, moderate range bone formation, which means that probably didn't occur within that 14-day window. And outside of 21 days looking back, it was difficult to tell how old those injuries actually were. I asked Dr. Thackeray, could you tell by looking at a child that the child had broken bones? His answer was no. I asked, short of x-raying that child, could you tell that child had broken bones? He said no. He also said that the child not appeared irritated on that day. Additionally to that, he said there were no signs of swelling on the head, no signs of swelling on the body, no protruding bones, nothing sticking out that would indicate to the person that those bones are actually broken. Dr. Thackeray did say that breaking of the bones is abuse. Dr. Thackeray did not say who caused that abuse. Dr. Thackeray then talked about some lesions on both children. And he said that those lesions were either caused by bugs, or by some kind of detergent, some kind of irritant. He got a little bit more specific and identified a couple of those as being bug bites. But those lesions were either bug bites or some kind of irritant on the child's skin. Jacob was charged and arrested for domestic violence on July 27, 2020. He spent 1 night in jail, which was released on July 28. He then moved out of the home. He continued to have contact with the children as he babysat the children from the 28th of July until the 12th of August. He was then arrested again and charged with domestic violence on August 13, 2020. He was released from jail on August 27, 2020. Temporary protection order terminated on September 3rd, 2020. Jacob told the officer that he may have caused injuries to the child as it relates to the ribs, by squeezing the ribs. Those were his words. As far as the testimony goes, a ton of inconsistencies, and that's what makes your job so difficult in this case. You heard from 3 people that had both children in their possession from the 19th of August through the 28th of August. That's a period of about 9 days, 9 to 10 days. Zaya Cloud said that she didn't see any bruises on the child. Sydney Prest said, yeah, I saw a couple bruises on the child. However, I just thought that was normal child stuff. Then Taylor Valerie, the babysitter who had the child for 3 days, testifies, I didn't see any children. I didn't see any bruises on the children. Now, this is an individual who took 4 photographs of the children. No bruises on the children in those photographs were apparent. She took a photograph of William because he was too small to fit in the car seat. Do you believe that she wouldn't take a photograph of a bruise if she saw one? She's concerned about the hair. She took a photograph of the hair. Additionally, Zaya had previously testified that she had cut out a good portion of that hair. Her testimony for Brittany. She took a stand in this case. She does make admissions that she was not truthful with the police during that day that she had. In her testimony, she says that she initially blamed Jacob Perkins for injuring the children when she talked to Dr. Manthor at the house. Said she didn't cause any damage. She then talked to Dr. Manthor in the car and said that Jacob Perkins caused injuries, and that she did not. She talked to Dr. Manthor at the police station, once again said that Jacob Perkins caused his injuries, but she did not. She then goes and talks to Dr. Manthor. Tells Detective Manthor a story about how she may have laid the child down too hard and hit the head too hard. And then says today that that's not actually the case, that she witnessed Jacob slamming the child's head against the wall. Same thing about the arm and the leg. Initially takes responsibility for pulling the leg through the crib and the arm, and then says, no, I actually witnessed Jacob do that on two separate occasions. When asked why she didn't contact the police or tell the truth, she said that she was scared for her life, that she had been threatened with her life, that he had threatened to kill her. She said anything. She testified that she was terrified. Seeking medical attention for children was asked. You saw this, and why didn't you seek medical attention? She initially said, well, I believe Jacob was taking the child to the doctor, as evidenced by his previous visits to Dr. House. Then she said, I didn't notice anything different about the children. They were happy, giggling, didn't notice anything different about them. Nobody, before September 9th, saw broken bones with the children. There's a ton of people who testified. Not one person, before September 9th, saw broken bones. Dave Claude didn't see a broken bone, or suspected a broken bone. Sidney Preston didn't see a broken bone, or suspect a broken bone. David Ballard didn't see a broken bone, or suspect a broken bone. There were 3 visits to Dan Risley, nurse practitioner, testified. She saw Lucy on June 11th, 2020, July 23rd, 2020, August 6th, 2020. She didn't see any signs of broken bones or bruises. When asked, are you a mandatory reporter? She says, yes, I'm a mandatory reporter. I would have reported that if I did see that. She did not see that. The state had their opportunity to cross-examine Ms. Haynes and to test her truthfulness, her credibility about the story that she had just told on the stand. They confront her with something about a cigarette. The state had access to every single Facebook message that she had ever sent or received. The state had told her that on the stand. Made it very clear to her, we have every single message. Do you want to change the story? She didn't change the story. They found one message about a cigarette. Then they confront her about her work schedule. Isn't it true that you work 8-hour days? Isn't that what you testified to? Yes. Are you sure? Yes, I work 8-hour days. You don't want to change your testimony? No, she didn't want to change your testimony. I have every single message that you have ever sent. No, I'm not going to change my testimony. It was later discovered that she worked 7 hours on one of those days in July. She was off by 1 hour. Then, my client testified that she had COVID-like symptoms. 105-degree temperature, which I don't even know if that's a real temperature or not. What do we cross-examine her with? What do we confront her with? Out of all these Facebook messages, what do we confront her with? Her sexual habits on September 7th, 2020. To prove that she didn't have COVID or COVID-like symptoms. Oddly enough, from the testimony that was here over the last 2 days, Brittany said that she had COVID-like symptoms leading up to the 9th and on the 9th. Detective Antoine also testified that he was gone for the next 15 days. Detective Antoine was in the same room with Brittany. Actually, interviews with her.
Objection.
Not approach.
You also heard testimony from Ms. Haynes about people waiting for the children. Children were underage, and children were taken to the canines on several occasions. Canines and children. Brittany did take Lucy to at least one of those visits. I believe that Jacob took the children to the other 2 visits by his testimony. And that Jacob had taken visits to his Ashley regarding Brittany says that she was never told of that that Jacob had never told her about that. That being said, she said she didn't notice anything about the children that was a little off or a little different. The weight wasn't too concerning to her. I would ask you to look at my client and make physical observations of how big my client is as well. The thing that really doesn't add up in this case is this written agreement. Jacob Perkins says was executed on September 8th, 2020. In this agreement, Jacob Perkins says, I wrote the agreement. However, Brittany told me what to put in that agreement. As you'll see, it's Exhibit 69. As you'll see when you go back there. In that agreement, he agrees to take all responsibility for all injuries and all medical appointments for that child, for Lucy Haynes. If the children had bruises on them on September 8th, why would he agree? Could it be because the children didn't have bruises on that day? Those bruises were caused on that night or that morning? Or could it be he's just taking responsibility for what he did to that child? Because he knew that child had bruises. Because he had caused them. The state will probably argue regarding that letter. He just signed it just so he could get the child out of there, just to get that child safe, to remove that child from that home. If that were the case, he would have taken the child immediately to the hospital. He didn't. He would have taken the child immediately to the hospital the next day. He didn't. At 4:09, he sends a text message, a Facebook message that says, child's moving in her arm. Okay. Didn't take it until that night. Now, the state having access to every single Facebook message sent and received from Brittany Haynes did not produce one photograph of a bruised, abused child prior to September 9th. (6/11/2020), and Nisley said there's no bruises. 7/23/2020, and Nisley said there's no bruises. 8/27 or 8/6, and Nisley said there are no bruises. And only one individual who babysat the children from August 19th to August 28th said that the child had bruises. A ton of witnesses appeared in this case, potentially 11, somewhere in there. Not one witness said they saw Brittany Haynes harm these children. Not one. That includes Jacob Perkins, a person who lived with Brittany Haynes for over a year. He said he never noticed any bruises on the children. He said he never noticed any broken bones. Not one person pointed to her as the person that caused these injuries by actually seeing. Out of all those Facebook messages, out of all ones that she has ever sent or received, not one is she in there admitting that she caused the harm to these children. Out of everything. Squeezing of the ribs. Jacob testified that it happened in the end of July of 2020. Brittany testifies after July 26th, 2020. Both of them from the possibility, obviously July 26th is within the latter part of July. Brittany says he squeezed the child, and it wasn't because of me. Even though it's Detective Anymore, that is the reason why she disagreed with that statement. That yes, he squeezed the child, but the second part of the statement was because it wasn't because of me. Jacob said it was because of her. She says it wasn't because of her. Either way, they both agree that Jacob squeezed that child in the latter part of July. Which brings you back to the bone formation question. Out of those ribs, 9 of those had moderate to abundant bone formation. Certainly can't be excluded as the time that those ribs were broken. We looked at the defendant's house, and yes, it's a disaster. Bugs in the house, crib, appeared to be dirty. So did her bed. That's how she lived. Wasn't the best situation to be in. She's 18. Doesn't have really any money. And yet, that's how she lived. It's not like she treated the children differently than she was living herself. Her own bed was dirty and soiled. If you look at the evidence presented, when Jacob Perkins was on the stand, he was given packets of Facebook messages, 10, 15 pages long, and he was asked to just go through and pick out if anything was interesting. Go through, find something, say, oh yeah, this is interesting. Okay. Then move on to the next exhibit. This is interesting. Move on to the next exhibit. Then I think there's a question. You see the part where it says William comes first? Yeah, definitely see that. Next exhibit. You have to look at things in context. In cross-examine, we read a little bit of that, put it into context. I think, if I recall correctly, I think it was something like, did you feed the children? Their response. Did you feed the children? Or did you feed William? Did you feed William? His response. No, I'm in the bathroom doing something with the cats. William comes first. You see how when you pick and choose through a whole Facebook message, how you can make, if you have access to every single text message she's ever sent, every single message that she's ever received, you just pick and choose, put up evidence, it could be a little deceiving. Now contrasted with when Brittany took the stand, it was start reading. She read it. She didn't want to. She read it. She read 2 pages. Take it one time. It was reading until I say stop. There's some stuff in there. She read it. Try to give you a little more context. But I do also say that it's really hard to get context in 1 page of text messages, just to pull that out. When there were tons of messages. The William had cyst on his testicle. Wasn't really a lot of testimony as to what caused that cyst, other than my saying that she calls him Jacob Hurts punching him sometime in May 2020. But they initially thought it was a hernia, and then they don't know what actually caused that. The state that put up a chart, which I think was looked at, understand what it probably said. They're probably going to try to convince you that Jacob Burger was in jail, nobody could cause his injuries. You have to remember, these bones are different healing stages. A lot of those healing stages overlap. And we know for sure that some of these were at least wouldn't even show bone formation until 14 days. Out past 21 days. With no tail on that. So when the child is born, it's hard to tell. The doctor could not tell me how long those fractures were healed. Because there's abundant bone formation. So it could be a month old, 2 months old. There's no way to know. But if that is true, then why did somebody catch it? No one caught it. It has to be true. It has to be true. It has to be at least 14 days on the ribs. Now there are some that have no bone formation. Those are a lot more recent. Those are within the last 10 days. We're talking 10 days, we're talking from September 10th, because that's when the x-rays were. September 1st. Now, you know, the state also says, well, Jacob wasn't here this day, this day, this day, this day. Brittany does say that he was there on the 3rd. Brittany says he was there on the 28th. The TPO slows down on the 3rd. There are a ton of inconsistencies in this case. One thing that both the mother and the father agreed on is that he squeezed that child. And it cannot be excluded as a time when those bricks were broken. And if you believe, or if you find it reasonable to believe that Jacob caused those injuries to those ribs, it's not out of the question to find it reasonable that he may have created some of those other injuries. It's not out of the question. The state of Ohio has the burden of proof in this case. They have to prove to you, beyond a reasonable doubt, that Ms. Haynes caused serious physical harm to Lucy Haynes, abused Lucy Haynes, and abused William Haynes. They have that burden. We do not have the burden to show that she is innocent. They have the burden with their evidence that they put on. We do not believe that they have met that burden in this case, based on the inconsistencies, based on the things that were established to be true. Facebook Messenger? Okay. Jacob Perkins says that he logged on to her account. Perkins says he gave her the password. Jacob says he gave her the password. Okay. Clearly they were using the accounts. He was logged on hers. I don't know if she said that she was logged on in his. They clearly had the passwords. He was logged on. Because the state has not met their burden of proof in this case, we are asking that this jury return a verdict of not guilty as to counts 1, 2, and 3. This is like, thank you.
All right, that's all we have to take.
I'm not sure if Mr. Justice George and I sat through the same testimony of Dr. Thackeray yesterday. The testimony of Dr. Thackeray is actually that there were bones broken in the past 7 to 10 days because there was no new bone formation or a small amount of new bone formation. He said that's absolutely in the last 7 to 10 days. Mr. Justice George did try to get Dr. Thackeray to say, this is exactly when this happened. This is the exact day. This is exactly how long this happened. And if you remember on recall, Dr. Thacker wasn't really comfortable with doing that. And when I had the opportunity to re-examine him, he said it's not intended to be this happened 3 days ago, this happened 4 days ago, this happened 7 days ago. It doesn't work like that. You know, that bone typically starts reforming between 7 and 10 days. So if there's no new bone formation, you know that's in the last 7 to 10 days. Beyond that, it's really hard to tell. And when they say moderate, acute, or new, they mean nothing, little, more. It's not 5 days, 10 days, 15 days. Remember his testimony when I got to re-examine him on that. The one thing he did say, other than the new bone formation, was that he was not comfortable going back more than 24 days. I'm not comfortable saying these bone breaks or these bone fractures are older than 24 days. That was his testimony, the expert's testimony. So let's do a little math here. Let's go back 24 days from the 8th. That puts us on the 16th. Where's Jacob on the 16th? Jail. Let's go back. Let's give him the benefit of the doubt. Give him a couple more days. Clear to the 13th. He's in jail. The expert medical opinion is, I'm not comfortable saying that any of these breaks are older than 24 days. Jacob is in jail. Even now, the defense is still blaming. This is Pam Myerson's fault. She didn't report anything she saw. She's a mandated report and didn't report. She last saw the kids on August 6th. And we know from the expert medical opinion, he's not comfortable saying these breaks are older than 24 days. That's the 16th. She last saw the kids on the 6th. She saw them before breaks. Taylor, Sydney, Zaya, again, blame, blame, blame. It's their fault. They should have known. They should have told somebody. Are they medical professionals? No. And the doctor, under the defense's questioning, said, no, you probably wouldn't know these were broken if you didn't have an x-ray. These three aren't medical professionals. It's not their fault. We know the irritants on her body, on his body, you know, it wasn't a soap irritant because you got the pictures of these kids. They're filthy. They weren't getting made. They're sort of soap. I want you guys to look at the agreement. State Exhibit 69, pay close attention to it because if you remember the testimony from the defendant yesterday, it was, I didn't sign this. He must have signed my name. I want you to pay close attention to that. There are two very different signatures on that agreement. And then today, the closing is, there are bruises on both of these kids on the 9th. So Jacob must have done that, and he signed the agreement. So, because he was taking responsibility for what he did. But he didn't have William. So how did he put bruises on your children? He didn't have them. He only had Lucy. It keeps being said, the kids, the kids, the kids. Jacob went and picked up Lucy, not William and Lucy. Now, of course, there are no pictures or no admissions from Facebook of the abuse that the defendant inflicted. Why in the world would she put that on Facebook? Now, the defense wants you to believe that because no person, no eyewitness came forward and said, I saw the defendant abusing these kids, must not happen. There's no eyewitness. Ladies and gentlemen, this doesn't even make sense. Imagine, there's a murder tonight. Person lives at home alone, someone walks into their house and shoots them. There's no eyewitness because the victim's dead. Does that mean we can't charge that person with a crime and they can't be convicted? No, that's ludicrous. That's absolutely ludicrous. It's not the law. You don't have to have an eyewitness to have a crime and a conviction. The defense also had access to all these Facebook messages. Yet they presented no context for the defendant's statements either. They didn't present statements of Jacob that did anything. They want to blame him. They didn't present any of that. You don't have any pictures of the kids without bruises from the defendant. There are a ton of inconsistencies in this case, but they all come from one person. They all come from the defendant. Her statements, it was Taylor, it was Jacob, it was David, it was Sydney, it was William. Yeah, I agree. Ton of inconsistencies. But none of them came from the state's witnesses. They all came from the defendant. Now, I'm sure that during this trial, there were things mentioned that weren't developed. I want you to be mindful of the judge's instructions. There are often legal reasons for what we are allowed or what we are not allowed to present to you. As the judge instructed you, the evidence and testimony to be considered in this case is what you heard from that witness chair and the exhibits that you'll be able to review in the jury room. In considering the testimony and evidence, it's important to remember that nothing that the defense attorney said in his questions is evidence. The only thing that's the evidence to consider is the answer from the witness chair. And one of your main jobs as a jury is to weigh the credibility of the witnesses. And to do this, you apply the truthfulness test that you apply in your everyday lives. You look at the witnesses' appearance on the stand. You look at their manner of testifying, the reasonableness of their testimony, their opportunity to see, to hear, and know the things they are testifying about. Look at their accuracy of memory. Look at their frankness, their lack of frankness, their intelligence, their interest and bias. Taken with all the facts and circumstances surrounding their testimony, and with all of that in mind, you guys decide who to believe from that witness chair. Let's apply this to some of the witnesses you've heard from over the past 2 days. Most of the witnesses you've heard from are people who didn't ask to be relevant. Most are people that were used for various purposes by the defendant, people who had no idea how they would work later turn into a scapegoat for the defendant. People who observed problems with William and Lucy, that didn't want to believe that the defendant, William and Lucy's mom, would be the person abusing these babies. Taylor, Sydney, and Zaya, babysitter, half-sister, half-sister's half-sister. These three all fall into the use, blame, get rid of category. A category the defendant developed. She told Zaya and Sydney that she had suffered a death in her family, needed to go to North Carolina for a funeral. Yesterday, she stuck to that story until presented with some Facebook messages and some different things. And then did, well, I also went to see something. But it was a friend that died, Angie, close friend, no last name, can't remember it. When Sydney and Zaya told the defendant, you need to come back and get your kids, again, she lies. She says, my car's broke down. And then says that mom's on her way there. And then she says, my mom's car also broke down. Now we have to take a train back to Ohio. The defendant then chose to return to Highland County, and she set up a date with another man. Didn't go get her kids. She went to Jamestown. The next day is the first day that she uses Taylor Valley, the babysitter. Again, the defendant used Taylor, promising to pay her for babysitting William and Lucy. Of course, we know the defendant did never pay Taylor. And then the blame game started. Taylor doesn't hold a grudge for not being paid, but being blamed for child abuse. When confronted with injuries to Lucy and William by Jacob, the defendant immediately blamed the babysitter, Taylor. The defendant told Jacob Taylor put marks on the kids and that she put bruises on the kids. The defendant wrote quite a story, and you'll get to read this in the messages back and forth between Jacob and the defendant. She wrote quite a story about an attorney, and she continued to blame Taylor even when being interviewed by law enforcement, until she was confronted with the facts. She said, "I blocked Taylor on Facebook." Well, not exactly. Actually, you blocked Taylor on Facebook because you didn't pay her. Again, you don't have to take my word for it. You have States Exhibit 11 to review Taylor and Brittany's Facebook messages. The fact is, the defendant never accused Taylor of harming her kids. She just decided, I'm not going to pay her, and tried to cut off contact with her. Brittany said Taylor's name like the police would just say, "Oh, okay, the babysitter did it, case closed." Well, no, they actually investigate. They go and talk to Taylor. When confronted with gun fights on the children, again, that's because of my sister and my sister's sister. We know from their testimony the kids were covered in bites and rashes when the defendant dropped them off at Sydney's house. And again, you don't have to just rely on Sydney and Zaya's testimony. You can review the defendant's own words. And her message to her mom on August the 18th, which is the day before she took the kids to Sydney, that says, "He's got BB bites all over." And I asked her, bed bug bites, correct? Yep. That was on August 18th. It's not Sydney and Zaya's fault. They hadn't been there yet. They didn't go to Sydney and Zaya's until the 19th, when the defendant went to North Carolina. The only person in the group of the defendant, Taylor, Sydney, and Zaya with a reason to lie, the defendant. Pam Knisley, the nurse practitioner, and Dr. Thackeray, they're medical professionals. They observed the children. They had immediate concerns with the children. They came to the conclusion that both children were being abused. Their profession requires them to be objective. They're here to make a diagnosis, and they are here to make a prognosis, and they are here to make a plan to get these kids healthy again. That's their job. That's it. But of course, the defendant saw an opportunity to use Pam in her lies. The defendant told detectives that she had taken William and Lucy to the doctor. The doctor found nothing wrong with these kids. Of course, we know that whole story is a lie. She never took the kids to the doctor. That responsibility fell to Jake. He pushed them on August 6th in a double stroller, clear to Pam's office, and back 3 miles. And Pam didn't see problems with the children, weight problems. She immediately suggested he take the children to the hospital. The defendant didn't follow over this order, just as she ignored other orders to get big checks for these babies. Again, it's Brittany's way or no way. Certified nurse practitioner Pam Knisley and Dr. Ron Thackeray are medical professionals with no bias in this case. Both came to the same conclusion. These babies were being abused. Kim Luke, Amber Schiller, Julia Maxwell. Kim Luke, Amber from Highland County Child Family Services. Julia is the foster mom that happened to see. They really have a unique role in this case. They are not concerned with who caused these injuries. Their total concern is William and Lucy. They have described the scenes as best they could. They tried to convey the filth that these babies were living in, the neglect these children suffered, the pain these children suffered, and how these babies continue to suffer because of the defendant. These 3 witnesses have no interest in bias in this case. They simply want what is best for these babies. Their goal, protect these kids. That's it. Next, you have the testimony of the detectives in this case to consider. Again, they presented their testimony and evidence. You can weigh their credibility from the stand. Now, they had the unfavorable task of wading through the many lies of the defendant until she finally found a connection with Detective Van Norm, really started telling the truth. In fact, became so ready to talk that when he tried to leave the room, she'd stop, come back and write something else to it, come back and write something else to it. They had no bias or interest in this case. Detective Van Norm was going to get a bonus, one way or the other. Their job, follow the evidence. That's what they both testified to. I asked them, did you have tunnel vision in this case? Remember Detective Ingles' testimony? No, I didn't have tunnel vision. I didn't want to believe a mom would act like this. They didn't have tunnel vision. They have no bias. They follow the evidence. The evidence in this case led to one person. It led directly to the defendant. Now, the defense has gone to great lengths to blame everyone else in the defendant's lives for the harm that William and Lucy suffered, but no person has suffered more blame and accusation from the defendant than Jacob Perkins, the father of William and Lucy. He's been used and abused by the defendant. Is he faultless? He's not faultless in this relationship, no. The relationship between him and the defendant, it was rough. He had concerns about how the defendant treated the children, and yet he can move back in to protect the children. Of course, it's hard to move back in and protect when you're sitting in jail. But did he and the defendant have physical altercations? Absolutely. Does that make him a child abuser? Absolutely not. Look at the evidence in this case. As the defendant is calling her 1-month-old a fucking bitch that whimpers, Jacob tells her, stay calm, go outside, take a breather if you need to. As the defendant is telling Jacob that William comes first, he's also trying to make sure that Lucy's cared for. As the defendant is complaining about how the kids won't quit bitching and it is ruining her social life because she can't go on a date, who's the first person to say, hey, I'll take them? It's Jacob. When the kids needed to go to the doctor, who took them? Jacob. Pam's testimony, the certified nurse practitioner, her testimony was that Jacob was very attentive and vocal about his concerns for the kids. Jacob knew he had no rights to the children. That was obvious from the way the defendant threatened to have a rights to her kidnapping. But as soon as he was given a chance, as soon as she said, come get Lucy, I refuse to raise Lucy anymore, what did Jacob do? Immediately, 9:15 at night, what did he do? Drove straight to Brittany's house, gathered up Lucy, and took her home. As soon as Jacob realized something was wrong with Lucy, the next day, he took her to the hospital. From the moment Jacob took Lucy to the hospital and law enforcement started questioning him, Jacob was forthcoming with them. He handed over his phone. There you go through it, take pictures. Remember the testimony? He identified the pictures that Detective Eagle took. She said, I took these pictures off Jacob's phone. Now, this is somebody with stuff to hide. Why in the world would you hand your phone over to the cops and let them take pictures off of it? He had nothing to hide. He was forthcoming right from the start. Jacob's bad behavior is actually a saving grace in this case. Because from July 27th on, he had very limited contact with William and Lucy. And from August 12th until September 8th, he had no contact with William and Lucy. He was in jail, and then there was a TPO in place. Now, the defendant wants you to believe that Jacob was so scary and so abusive that she was covering up for his actions. She was scared to death. But think about this. If he was so scary and so abusive, why did she beg him to come back? She offered him money to come stay with her. She offered him sex to come stay with her. The answer is simple. The defendant was not afraid of Jacob. Her claim of being afraid is just another attempt at blame and a way to get attention. In fact, when Jacob didn't do what she demanded, she called the sheriff on him. This was not a domestic violence being reported, but rather a way to get back with Jacob for not doing what she wanted. Again, don't take my word for it. You have the evidence that states Exhibit 106. Fine, you want it this way, you want to meet my shift, the sheriff's coming now. You done messed up, so have fun sitting in jail again. Let's bring the statements to Jacob. The defendant's statements to Jacob. You didn't do what I wanted. You're going to jail. Jacob was regularly the defendant's fall guy. She blamed him for William's testicles being swollen, and when confronted, she admitted in a Facebook message that Jacob didn't hurt William. She blamed Jacob for drugging her, but again, when confronted, I'm sorry, I didn't even remember saying that. When Jacob last saw Lucy on August the 12th, his testimony was that she didn't sound like a bag of potato chips. The damage done to William and Lucy after Jacob was done after Jacob was out of their lives in August. The medical expert testified that these breaks occurred within days of the x-ray to 3 weeks of the x-ray. He said, I'm not comfortable with saying these are more than 24 days old. That was his testimony. Jacob couldn't have done these injuries. He was physically unable to. He spent most of that time in jail. If Jacob did cause these injuries, why did he need to ask the defendant about the injuries to Lucy when he got her? Why did she make up the story about the babysitter as outlined in the messages between Jacob and the defendant in State's Exhibit 7? So if you remember, he says something's wrong with Lucy's arm. She says, don't give her a pacifier while I wanted to try to move her arm. She says, don't move her arm. It's been dislocated. The babysitter did it. Don't get involved in this. I already have attorneys investigating it. Remember all that testimony? Those are the pictures that were taken from Jacob's phone by Detective Eagle, and here you have it all. You can read it all for yourselves. If Jacob did the injuries, why does he need to ask who did these injuries? And why does the defendant need to make up this insane story about the babysitter and attorneys and an investigation? It's because the defendant did these injuries, and she knows that Jacob didn't do it. Look at the behavior of Jacob in court. Now, he remained very calm during questioning, even knowing from the defense's questions that he was being blamed for this. He knew after the defense started questioning him, she's trying to make me the fall guy. Yet he remained very calm, very forthcoming, answered the questions. Again, the only person in this relationship, Jacob and Brittany's, that has a reason to lie about Jacob's action is the defendant. Because only the defendant will benefit from lying about Jacob. Now let's look at the defense's witnesses. Todd Markley, the expert in computer analysis, who said the defendant's Facebook account was logged into on separate occasions with an IP address that was different than the one on her phone. My first thought on this was, who cares? What does that have to do with who broke 22 bones in baby Lucy and gave her a skull fracture? What does Facebook logins have to do with neglect and starvation and maltreatment of little William? I submit it doesn't amount to a hill of beans. Mr. Markley cannot tell you who logged in with a different IP address. In fact, he admitted on the stand, if the defendant had been at the library using the free Wi-Fi, different IP address. Using her other cell phone, she had two from the pictures from the search warrant, different IP address. If she asks to borrow someone else's phone and logs in from their phone, different IP address, it doesn't amount to anything. And we know that while Jacob is being blamed for logging in under her account, the defendant gave Jacob the login information. You can see it in multiple Facebook messages. States Exhibit 89, States Exhibit 90, States Exhibit 91. And then the blame of Jacob for his Facebook activity and all this suspiciousness really falls flat when you look at the calendar and you see that he was in jail when several of these Facebook messages were sent. As you know from the testimony of Detective Antonor, who said, I got my start in the jail. That's where I started. Jacob had no access to a computer, no access to a cell phone, no access to Facebook while he was in the Highland County Jail. So again, I submit, who cares who logged into her account? Does not amount to a hill of beans. Just one more attempt at the blame game. And last to testify was the defendant herself. Now look at her frankness and her ability to remember things when questioned, and you judge her credibility. And then remember how many times she gave an answer and then had to backtrack or kind of change it, like confronted with Facebook messages in which she had given a different answer. It started from the very first set of questions when I asked her about going to North Carolina. She couldn't remember the name of the dear friend who died. And then remembered, well, I also went to see CJ. Then look at States Exhibit 113. conversation with A.J. Conley because she had testified on direct. She got back from North Carolina, she didn't have a car, she had to wait till the next day for her mom's car to transfer to her or something to that effect, and I said, are you sure you didn't drive anywhere that night? Nope, didn't have a car. Well, then you can read and see, I got mom's car and I'm on my way. And you can see how he's telling her where to go. When you get here, when you have 10 minutes before you get here, let me know, I'll come out and meet you. And then she says, I got home at 4 o'clock this morning. Well, but then her testimony was, I didn't really know. And I said, oh, this is pretend? You guys were role playing? That's nonsense. She also testified under oath that she didn't have a vehicle. I'm sorry. The defendant claimed she wouldn't have driven to AJ's because that would have been illegal. That was her testimony. But just before that, she admitted that she had driven to North Carolina and her van had broke down on the way back. So, I don't know. The defendant told you she tried to stay in a relationship with Jacob for the children, and then the next breath told you that Jacob was the one abusing the children. This lies in the face of common sense. The defendant testified under oath that she loved her children and that she never said she didn't want them. But then she was confronted with the Facebook messages to Cindy on August 17, State's Exhibit 115, where she says, I don't want to be their parent anymore. I've already been forced not to live my damn life, and I'm not going to be forced to keep kids I don't want. Again, you have it. You can look at it yourself. The defendant couldn't even be honest with you about her smoking. The cigarette thing's not a big deal, but it just goes to show that be honest about something. The same message with Mom, August 17, I need a cigarette, I'm about to go crazy. I could go on and on with each question asked and answered, but you saw it. You saw what happened when she took the stand. Then consider how quickly the defendant lost her cool on the stand. You have the defendant saying, Jacob's the one with the temper, he's terrible. You lose his cool? No. Nope. He sat there, forthcoming, answered the questions, didn't even blink an eye. Nothing to hide. Took about 5 questions before the defendant started cussing at me from the stand. Who has the temper? The defendant. Now look at the elements of the crimes alleged and the evidence and testimony that proves each of these crimes. Remember what I told you in court here. I only have to prove each element of the offense. If I don't prove the temperature on the day this happened, it doesn't matter because the temperature is not an element of the offense. If I don't prove what color socks the defendant was wearing when she put her knee down on baby Lucy and broke her leg at the knee, doesn't matter because the color of the defendant's socks. It's not an element of the offense. So starting with felonious assault, which is on page 5 of your jury instructions. In order to prove felonious assault, the state must prove that during the period of June 14 through 2020 and before September 9, 2020, in Highland County, Ohio, the defendant knowingly caused serious physical harm to Lucy Haynes. The defendant lived at Headover Trail, everybody agrees to that, and that's in Highland County. And these injuries occurred in her home. Now there is no question that baby Lucy suffered serious physical harm. She had 22 bone fractures and breaks and a skull fracture. Now, I don't have to prove each definition of serious physical harm in order to prove that she suffered serious physical harm. Your instructions say any, not all, but any. But the state didn't prove all of these. The state proved that Lucy suffered from a mental illness or condition of such gravity as would normally require hospitalization or prolonged psychiatric treatment. Dr. Thackeray said absolutely. Any physical harm that carries a substantial risk of death. I asked Dr. Thackeray that. The expert in medical child abuse. He said absolutely. Any physical harm that involves some permanent incapacity, whether partial or total, or that involves some temporary substantial incapacity. I asked Dr. Thackeray that. He said, absolutely. Any physical harm that involves some permanent disfigurement or that involves some temporary serious disfigurement. I asked Dr. Thackeray, did Lucy's injuries meet that? Absolutely. Any physical harm that involves acute pain of such duration as to result in substantial suffering, or that involves any degree of prolonged intractable pain. Acute pain, ladies and gentlemen, we're talking 22 broken bones in a 3-month-old. I asked Dr. Thackeray. He said, absolutely, Lucy suffered from that. The only evidence you have is that Lucy suffered serious physical harm. It is the uncontested expert medical opinion from an expert in child abuse. Lucy's injuries meet all 5 definitions. Think back to the defendant describing the way she put all of her weight on Lucy's little leg. An infant, she's just over 2 months old. And this is just before slinging her head into the floor. That's when one of those femur bones broke. That's when that skull fracture happened, the water bubble on the back of her head. The question then becomes, did the defendant cause this harm knowingly? The answer is absolutely yes. Look at the defendant's actions. You don't need to hear her say, yes, I did this knowingly. You can look at her actions. Circumstantial evidence proves this. She refused to take Lucy to the doctor. She refused to take Lucy to Children's Hospital. She described Lucy as sounding like a bag of potato chips, yet she didn't take Lucy to get medical treatment because she caused the injury. What did she tell Detective Angela and Detective Engel? I don't want to go to jail. I don't want CPS involved in my life. And that's more important than taking care of your child. She did these knowingly. Look at State's Exhibit 112. This is a message to Chris Casey. She says, Mom said, get the kids to JP's, Jacob Perkins, so he can watch the kids, then me and Mom will take you. She wants to go to the hospital. This is on September 7th. Brittany says, no. Do you really want him to see the bruises on their faces? Really so effing smart. I need to go right effing now. I'm done playing effing games. Chris says, call us the law. Brittany says, I'm not taking the effing kids. I have marks on them. She knew what she was doing, ladies and gentlemen. Finally, when she gives Lucy to Jacob, she makes him write that he is responsible for Lucy's injuries. State's Exhibit 69. If she didn't know that she caused these injuries, why did she put that in a custody agreement? Wouldn't it make more sense to have in a custody agreement? I get to see the kid, I get to see Lucy every other weekend, or I get to see Lucy on Wednesday evenings, something like that. I don't know, what would you put in there that the other party is responsible for all of her injuries? It's because she knew. She knew already what she'd done. There's no reason to consider it a lesser offensive assault, because the state has proven each element of count 1 felonious assault beyond a reasonable doubt, and the defendant is guilty of this charge. Now, the next crime the defendant is charged with is endangering children after Lucy, which begins on page 13 of your jury instructions. Again, the state must prove that this occurred between June 14th and September 9th, 2020 in Highland County. We know the defendant lived on Heathermore Trail, and we know these injuries occurred in her home. Next, the state must prove that the defendant abused Lucy, and Lucy was under the age of 18. So, did the defendant act recklessly in causing injury to Lucy? Yes. Look at her explanation of Lucy's arm being stuck between the crib and the wall, and her jerking on it and hearing it pop. She admitted that she pulled on making Lucy too hard. She knew it. The defendant acted with heedless indifference to the consequences of her action, and she thought it would be a great idea to jerk her baby girl out of that crib. This is not a remote possibility. If it were one broken arm, maybe an accident. Lucy has 22 broken bones. Obviously, Lucy was less than 18. She was only 3 months old when she was rescued from the Now next, the state must prove the defendant abused Lucy. Abuse is any act which causes physical or mental injury that harms or threatens to harm the child's health or welfare. I'm not going to go through all this again. All I'm going to say is 22 broken bones, that's physical harm. Now once you find that Lucy was abused by the defendant, you must also find that Lucy suffered serious physical harm. I'm not going to go through all of it again, we just did it. But Dr. Thackeray said every single one of these applies to Lucy, every single one. He's proving every element or every definition of serious physical harm. The defendant is guilty of child endangering as it applies to Lucy. Now, when you have the verdict forms, you'll see that it says, we further find and specify the violation of defendant did or did not result in serious physical harm. Ladies and gentlemen, circle did. She caused Lucy serious physical harm. Finally, the final crime is endangering the children as it applies to William Haynes. Page 16 of your jury instructions. Again, the state must prove that between June 14th and September 9th in Highland County, Ohio, the defendant was the parent of William and caused him serious physical harm. Dates have been proven. We know where the defendant lived on Heathermore in Highland County. Next, the state must prove that the defendant is the parent, guardian, custodian, person having custody or control, or person of local forensic. Nothing in that sentence matters because we know she's the parent. And it's, each of these doesn't have to be proven, it's one. Parent, guardian, custodian, person having or control, or person of local forensic. She's the parent. And again, there's no question William's under 18. He was 15 months old when he was rescued. Now, the state must prove the defendant acted recklessly to prepare William. Again, recklessness is heedless indifference to the consequences of her actions. Not feeding William and not providing care for him was reckless behavior on the defendant's part. Now look at the serious physical harm as it applies to William. The evidence is clear that William was in serious condition when he was taken to the hospital. He didn't suffer broken bones like Lucy, but he was suffering serious physical harm. The defendant was starving him to the point that he didn't grow at all from February 13th through August 6th. Ladies and gentlemen, you've got the medical records to take a look at. Dr. Thackeray observed William, and he came to the expert opinion based on his bruises, medical condition, food aggression, weight loss, developmental regression, and neglect that William was being abused. Dr. Thackeray also came to the conclusion that William suffered serious physical harm. Take a look at this. October 2019, he weighs 17 pounds 4 ounces. January 3rd, 17 pounds 8.5 ounces. February 13th, he's down to 17 pounds. August 6th, 6 months later, he's only gained 1 pound 5.5 ounces in 6 months. November 19th, he's up to 27 pounds 14 ounces. That little guy almost gained 10 pounds from August to November. He had the ability to do it, he just needed food. And look at his height. February, 31 inches. August, 31 inches. Cam nicely told you. Everything he's taking in is going to keep him alive. There is nothing left for him to grow with. As soon as he's being fed, he's taken out of the house. 31 inches in August, November, he's up to 34. This isn't something wrong with William. This isn't failure to thrive. This isn't organic. This is abuse. She's not feeding him. Look at State's Exhibit 17. The picture of Taylor's little girl, Baker's little girl, and William. William's sitting on the floor, and he's older. He's older than this little girl, and he's sitting on the floor, and the little girl is up. The size difference of these kids is amazing. She's 2 months younger. By August 26th, he's literally eating food out of a trash can. Remember Taylor's story about how he crawled to the trash can because her 6-year-old stepson was in away? She already fed William lunch. She thought they were done eating. Her 6-year-old throws food away. William crawls to the trash can and eats the food out of the trash can. He still suffers from food aggression. I asked Dr. Thackeray about it. He said absolutely he's seen kids go through this. He's terrified there won't be food. This will take a prolonged treatment. Dr. Thackeray told you it took William time to regress to this point. It's going to take time for him to come out of it. Let's go back to this. Again, the state only needs to prove one definition of serious physical harm. Your instructions say any, not all, any definition. Dr. Thackeray identified Williams' injuries as a mental illness or condition of such gravity as would normally require hospitalization or prolonged psychiatric treatment. Dr. Thackeray said his abuse was any physical harm that carried a substantial risk of death. That was his expert opinion. And it's any physical harm that involves some permanent incapacity, whether partial or total, or involves temporary substantial incapacity. Now again, William Haynes suffered serious physical harm. He suffered that harm at the hands of the defendant. The state has proven each element of child endangerment as it applies to William. And again, remember as you're filling out the verdict form, the part on the bottom, down here, we further find and specify the defendant did cause serious physical harm to William Haynes. Again, the state is not required to prove motive, but the motive is pretty straightforward in this case. These kids were cramping her style. She openly talked about putting both kids up for adoption. She wanted rid of them. She called them terrible names. Those babies were simply in her way. She was ready to be a single person, not a single mother. And these kids, they're just in the way. So neglecting them, abusing them, causing them serious physical harm, it was easy for her. When she was being questioned by law enforcement, she was more concerned with her cell phone than she was Lucy and William. She just couldn't wrap her mind around not getting that cell phone back. Remember her testimony yesterday? Now the state must prove each and every element beyond a reasonable doubt. And the defense submits, we have done that. Well, reasonable doubt is doubt based on reason and common sense. And you can equate this to your everyday lives and the decisions you make on a regular basis. Talk about buying a car. You shop around and you collect evidence, and you want a red SUV, and you find one, and the odometer says 50,000 miles. Your budget, and the payments on this particular SUV, $250 a month. Now your budget allows for a payment of $350 a month. This is everything you want in a car. All the evidence points to you buying the car, and you decide, of course, I'm buying this car. Now there is some remote possible doubt that this is not the perfect SUV for you. But reasonable doubt, doubt based on reason and common sense, has been overcome. And of course, you buy the car. It's not your job to look for reasonable doubt. If reasonable doubt existed, it would have presented itself from the evidence. There is no reasonable doubt. In this case, reasonable doubt, doubt based on reason and common sense, has been overcome, and the state has proven each of these crimes beyond a reasonable doubt. At the end of the day, you simply need to look at the defendant's own words to know that she caused harm to these babies. Her interview with Detective Anor sealed her fate. When confronted with her many lies, she finally admits that she's the one causing harm to these babies. Her blame game got her nowhere with Detective Eagle and Detective Anor. And why would somebody try to blame everyone else? Take the focus off themselves. It's the not me defense I talked to you about in Cordier. She even tried to blame little William for causing injury to Lucy. William, who didn't have the strength to hold himself up. William, who didn't have the strength to walk. She tells Detective Eagle, he was power with my daughter. He did this. Of course, lying isn't that big of a deal to a woman who break 22 bones in a 3-month-old baby girl and give her a skull fracture. Lying isn't that big of a deal to a woman that will starve her son to the point that he quits growing. A woman who has her kids covered in bruises, who neglects him to the point that he doesn't walk, he cannot walk or talk. Lying isn't that big of a deal to a child abuser. Doesn't even think about it. Ladies and gentlemen, at the end of the day, I'm asking you not to lose sight of what this case is really about. It's not about who logged into the defendant's Facebook account. It's not about how bad Jacob and the defendant treated each other. At the end of the day, this case is about two innocent babies. Two babies that couldn't protect themselves. Two babies that suffered at the hands of the one person that should have given her life to protect them, their mother. This case is about little William, who was starving to the point of eating out of a trash can, and who still suffers from the trauma of being starved. Little William, who stopped growing, stopped walking, stopped talking, and was covered in bruises and bites when he was rescued from the defendant. This case is about 3-month-old baby Lucy, who suffered 22 broken bones, who couldn't be swaddled in a blanket because to be held like that hurt too badly. She wanted to stretch out. Who had a skull fracture on the back of the head. The defendant said, "Felt like a water bubble back there." Baby Lucy, who was so broken that she sounded like a bag of potato chips when you picked her up. Now that you are focused on what this case is about, William and Lucy, it is time for you to start deliberating. It's time for you to review the evidence, remember the testimony, remember the pain and suffering of William and Lucy, and do the only thing here that makes sense. Tell the defendant the blame game didn't work with us either. Find her guilty of all charges. Find her guilty of abusing William and Lucy. Find her guilty of causing serious physical harm to William and Lucy. It's time for William and Lucy to get justice. Thank you.
All right. Ladies and gentlemen, I'll remind you again that closing arguments are not evidence to be considered. Now, we've been in this almost 2 hours, so we're going to take a break of about 10 minutes for convenience. During that break, like counsel, please knock everything off the tables. Since the jury will be deliberating here, and also remove any charge. And also they hope to get the exhibits that are, those papers are on the record.
Yes, Your Honor.
So you can bring, if you want to bring your cell phones in, we have plastic bags for each of you. Put your bag, your phone in, if you prefer it, rather than leave it in your car. Come back in 10 minutes during the recess. Remember the instructions I've given you not to discuss the matter with anyone permitted to be discussed in your presence, not to form any opinions yet. Not quite ready to do that because you haven't received the final instructions. Don't discuss the matter permitted to be discussed with anyone that's been involved in the case. So it is now 10:18, so let's be back here at say 10. And it'll take maybe about 15 minutes before we leave over.
Please rise. Okay, we're going back to the stream. And on the record.
All right, ladies and gentlemen, you've heard the closing arguments, which, I'll instruct you on all evidence. And I'm now going to instruct you on how to conduct your deliberations and your verdicts once you reach them. Now, you must be uninfluenced by any consideration of sympathy or prejudice. It's your duty to carefully weigh all of the evidence, decide all disputed questions of fact, to apply the instructions of the court to your findings, and to render your verdict accordingly. In fulfilling your duties, your efforts must be to arrive at a just verdict. Consider all of the evidence, use your common sense, and make your findings with intelligence and impartiality, without any bias, sympathy, or prejudice, so that the state defendant will feel the case is fairly and impartially tried. Now, if during the course of the trial the court has said or done anything which you consider, and in the case of my view of the facts or the case in general, you're instructed to disregard. As a judge, I must be and sincerely desire to be impartial, presiding over this or any other case or trial before the court with or without a jury, because the court has no right in any way to invade, and does not desire to invade the province of the jury or indicate a purpose between the parties. The court has not done so. And I'll explain why I gave you that instruction. Many years ago, I was a prosecutor and practicing attorney. I tried lots of jury trials, probably close to the country. And I had a client who had served a jury, and so I asked that client, I said, I never know what happens in the jury room. Would you tell me, how is it you came to your verdict? And his client says to me, well, we kind of watched the judge and kind of got an idea from him what our verdict ought to be. And I'm saying, oh my gosh, that's not right at all. I never had any clue that somebody might pick that up from the judge. So I give that instruction just to make it clear that my rulings are not based on any view of the facts. It's based on law, and those are the rulings I'm making. So don't take into consideration anything you think I might vindicate. Now, consult with one another, consider each other's views, and deliberate with the objective of reaching an agreement. If you can do so without disturbing your individual judgment. You must each decide the case for yourself, and you should do so only after a discussion and consideration of the fact with your fellow jurors. Do not hesitate to change an opinion if you find that it's wrong. However, you should not surrender an honest conviction in order to be congenial or to reach a verdict solely because of the opinions of the other jurors. Now, you may not discuss or consider the subject of punishment. In the event you find the defendant guilty, it is the duty to determine punishments placed by law upon the court. When you go to the jury room, your first function will be to select one of your number as a foreperson. Well, actually, you're going to stay in court. And that person you select will preside over your deliberations, but does not have any greater power, nor does that person's vote have any greater importance than any other juror. Foreperson serves the purpose of helping you to conduct your deliberations in an orderly manner and give each juror an opportunity to express your opinion. One additional duty of the foreperson is to see the verdict form and exhibits and copies of the instructions returned to the court after you reach the verdict. Until your verdict is announced in open court, when we're all reassembled and on the record, you're not to disclose to anyone else the status of your deliberation or the nature of your verdict. Now, I have prepared 4 verdict forms, and I know there was some reference to those in the closing argument, but I'm going to read them with the record. You will have those with you during deliberation in order to report your verdict. The first count will have the name and the case number, and the charge. And then in the body of the form, it says, we, the jury, having been duly impaneled and sworn, find the defendant and the defendant's name, and then there's a blank space of felonious assault, a second-degree felony, and she stands charged to count on the indictment. Then there's a couple of asterisks below the blank space just to remind you that's where you fill in the guilty or not. And then there are signature lines. And then in the event that you either find the defendant not guilty of felonious assault, or you're unable to agree as to whether the state proved all the elements of the offense of felonious assault beyond reasonable doubt, then you will complete the verdict form for assault, because you'll be required of instruction to consider that. So there's a verdict form for that, and it reads the same except it says assault. It has a section number. Otherwise, it has the same information, blank space, and a reminder to insert guilty or not guilty. Now, count two, endangering children, and it has a section number, and I also put out to the right the section number, initials LH, so it's clear which child that count applies to. And basically, again, it reads the same, blank space, insert either guilty or not guilty. Now, these two forms, second count, third count, have an additional finding if the verdict is guilty. If it's not guilty, you don't have to consider that. But if it's guilty, then you have to go ahead and consider and report your finding, which is we further find and specify that the violation by defendant did or did not result in serious physical harm to LH, the child involved in count two. So you'll circle either did or did not, or if you want to strike out the one that doesn't apply, just so it's clear that you've made a finding. And then count three is basically the same. It's a different section number, has WH or Williams initials on it. Otherwise, it's the same. And again, if you find that guilty, you have to consider and report on your additional finding whether or not the violation did or did not result in serious physical harm to WH. Now, there are 12 lines on each form, and you will sign the verdict form then after you reach your verdicts, because the verdicts must be unanimous. And so all 12, again I say all 12 have to agree on each verdict. Now the number of, and by the way, signing the verdict forms is your indication as a juror that this is your verdict as that to that particular count. Now the number of forms you complete will depend upon your findings in count one. If you find the defendant not guilty in count one of felonious assault, then you'll make a return verdict on counts that are on the lesser included of assault. So in that case, you have two. If you find the defendant guilty of the offense, then you would only, felonious assault, then you would only have one. Or if you couldn't make a reasonable decision on that, then you leave a verdict form for assault. If you haven't worked on that, then you have that. So basically, the way your findings will dictate whether you fill out one or both forms on count one. All right, now, and again, you will have copies of these instructions with you. Now, during your deliberations, you're going to be in charge of the bailiffs, and what I'll ask you to do is anytime you need to communicate with the bailiff in court, the bailiff will be right here in this office, go over here, knock on that door. This door will be locked, and there won't be anyone stationed outside of that. Now, the bailiffs are there to make sure your deliberations are not interrupted and your needs communication with the court. And if you have a question, they can't answer. Write it down, give it to the bailiff, then I will look at it, consult with the attorneys to determine the response that I can give to you. Now, if you ask me to explain the law further, it's all right in here. And if you're having trouble finding it, then and you ask me about it, then I'll say, okay, refer to page, whatever. But if you do have any questions on law, please look at these first. And then if you don't feel that you can find it in there, because it is a 23-page law, let me know. Now, during the deliberations, this is kind of a deja vu for me. I started as an attorney in April 1976. It was placed in Vermont. Back then, didn't have jury. And the back there, the left third to the front. So this is where the jury deliberated. We always did exactly what we're doing today. So it's the first time we've had to do that, and under the circumstances, 40 plus years. So it's kind of a deja vu for me. So I was used to it then, but it's a little different, of course, now. So, but to explain to you, you will be able to move around. If you want to leave the exhibits on the tables, if you want to wipe them down, we'll leave the wipes and the sanitizer there. I would say don't touch any equipment because we just got this installed in January and we're still learning. I trial and lots of errors. And so, in fact, the other day, I took a cable over here under the desk, under the bench, and messed a bunch of stuff up until we finally figured out that's no problem. Don't look at any books or anything behind the bench. There is a security camera on it. It's for the court security system. It's not sound, so we'll see what you're doing. If you have any questions, just don't wait. Just come over here and knock on the door. So now it's going to be, it's right about 10:40, and so what I would suggest is that you deliberate until through 12 or 12:30, and then you decide you want to break for lunch. Let me know, and then what will happen is we'll give you 1 hour of time that you decide to go to lunch. If you do go to lunch, that means you can leave the building and have lunch together separately, however you want to do it, but you're not discussing the matter while you're on your lunch break, even on yourself, because 2 or 3 of you are having lunch together. You're only those 2 or 3 of the jury. The jury consists of all 12 of you, and so you cannot conduct any deliberations separately. But we'll report what time. I just want to report what time you do leave for lunch, and then I'll ask you to be back in 60 minutes. Report that in writing, and then the bail will give it to me, and I'll put down the time for you to be back. And then the doors will be locked until the jurors start to return. Once you return, as you come in again, don't deliberate. If there's 2 or 3 or 4 of you, or 6 of you, or 8 of you, you cannot discuss the matter until all 12 of you are back together in the courtroom with locked doors. And you can't take your cell phones during that time with you, but you'll have to return again and come back. Again, during the breaks, you're not to talk with anyone else about it, communicate in any way, no social media postings, no reading of anything on the internet, papers, not to permit anyone else to discuss it in your presence, not to communicate with anyone who's been involved in the case. All of the instructions that I've given you throughout the trial. And again, you will have the admitted exhibits, which does include this chart that's in front of me. I can see it on the camera, so it's right here in front of me. And you have all the other exhibits here.
On the tray, Your Honor.
They're on the tray right here in front of the bench. Okay. And then there will be pads and pens also for you that are right there on the counsel table of the state for you to be using during your deliberations if needed. And we'll leave here's the copy of the instructions for the jury. All right, anything else?
There you go.
All right, in this case, you've been involved, put in 2.5 days. Unfortunately, I guess, depends the way you look at it. It's fortunate nothing happened at 12. Fortunate is that, it can be frustrating to be there for the whole time and then not have a chance to participate. But you are still under the instructions and your oath as a juror. And you're not released yet from service. You can leave the courtroom, make sure you give your cell phone number to the bailiff because you're subject to call until this jury has returned a verdict. Because if something should happen to one of them, then we will call you in to take that juror's place. The deliberation will have to start anew since you would have been involved in it, so they'll have to start over. But that way, if something happens, we can still get a verdict. And so, as I said, I think when we had the voir dire, I have had that happen twice in the last 10 years. And so, it was able to have those cases be concluded. So you're still very important. You're not allowed to talk with anybody or research anything, read anything on the internet, or let anybody talk to you about it. As soon as we do have a verdict, the bailiff will call you, and at that point, you'll be released from your obligation and your oath as a juror, and will be permitted to talk about it if you care to. You're not required to, but it will be up to you at that point. But until you hear from us, abide by all the instructions of the court. We want you to stay. Do you live within 20 minutes of the courthouse?
I live in Leesburg, it takes me about 15 minutes.
Okay, 20 to 25 minutes. So, yeah, you can go home or wherever you want to go, work or anything, but just be sure that you have your cell phone on and can be contacted if we need you. I don't think we will, but again, there's always that possibility. All right, with that then, everyone other than the jurors will vacate the courtroom and the deliberation will start. Okay.
she's supposed to across the street, so we could pay.